for others to clean up the mess that you had caused? That's so inhumane.
This sentencing revolves around a very serious accident. The impact of it was very significant for the victim, and now the court has to weigh the idea of justice and punishment against what would be in the best interest of getting that victim to be whole again. So watch how it plays out. My name is Dan. This is the Courtroom Files.
Okay, this is 24 CR 1338, the state of Texas versus David Medina. Correct, sir? You're Mr. Medina. Mr. Rojas is here representing you. Earlier in this case, you pleaded guilty to collision involving serious bodily injury or death, which was a third-degree felony, which carried with it up to 10 years in prison. An agreement had been reached when you entered. And has he entered his plea yet?
We have, Judge.
Yes, sir. Because it's not showing that
Back on March
on the
19th.
file. I don't even have anything on it here. What was the date?
March 19th.
Yes. A pre-sentence report has been prepared and the parties had an opportunity to review it.
We have here.
And are there any corrections or changes to this?
Not from the state.
No.
No, Judge.
You believe it?
I believe it's a valid partnership.
Then it's made a part of the record for all purposes. Has there been a determination of restitution? How much?
No, sir. I don't have anything, any correspondence. Well, that's why I was looking on the computer, see if there's something that came in that I didn't know about.
Judge, my client tells me that his insurance has settled with Mr. Jones on whatever portion they're responsible for. I don't know if those policy limits or not. There may be some amount above that.
Is the complainant here by any chance? The victim? No. Okay. Um. Where to begin? The circumstances here are disturbing that in February at 2024, which would have been 2 years ago, a little over 2 years ago, at about 7:30 p.m., 7:13 p.m. So that would have to be dark,
Yes, sir.
if not dusk. It certainly was dark. And Beaumont police went to College Avenue F. I guess that's College and Avenue F, an intersection there
Yes,
in
sir.
Beaumont, investigating a collision between a vehicle and a cyclist. And a witness had been following the vehicle involved in this. I guess that's the defendant's vehicle, Ford F-150. And officers subsequently located, detained the driver, who was the defendant, Mr. David Medina. And he confessed to hitting what he thought was a bicycle, panicking and fleeing to his home without providing assistance. Investigation later showed that the cyclist suffered multiple fractures, significant laceration, and was arrested and then ultimately charged with this third-degree felony of a collision involving serious bodily injury or death. And as far as the injury was concerned to the cyclist, he sustained severe injuries requiring approximately 8 months of hospitalization in 2024 across in three separate medical facilities, undergoing a surgical procedure in which part of his skull was removed, as well as the insertion of approximately 25 pieces of metal into his hip. Due to the severity of his injuries, he's no longer able to return to his prior employment as a carpenter and is now significantly limited in his ability to earn an income. He is currently trying to work for Uber Eats, but is unable to achieve comparable earnings to his previous employment when he was not injured. And that he has an ongoing financial hardship that has resulted in his current residence in a homeless shelter, of all things. Let's just get sadder and sadder the more you read. All right. What to do? The agreement here is whatever sentence shall not exceed a cap of 8 years imprisonment. So you were looking at no less than 2, no more than 8 years confinement in prison. Can I give him regular probation?
Yes, sir. This is not a one you do the deadly weapon finding on because.
Because there was a vehicle
Yes, but
is in its use and it caused serious bodily injury. It means it fits a deadly weapon. So we're not foreclosed.
you're not, because it's not, you cannot make a finding of a deadly weapon on a failure to render aid,
And
the
then there
collision.
could be deferred or unadjudicated probation.
Yes, sir.
Is that what you see, Charlie?
Yes.
Thanks. All right. Go ahead, state.
Judge, looking at the victim saying 8-year sentence is not enough, well, the most we can give him is 10. And giving him credit for taking responsibility is at least now and pleading guilty and confessing to it at the scene. I thought the 8-year cap was appropriate. That I still think the 8-year sentence is appropriate in this because it just leaving somebody there with those injuries, he could have died and it could have been a second-degree felony. Then we would have been looking at something else, possibly manslaughter charges, things of that nature. But because of the way the grand jury indicted it and looking at the seriousness of the injuries, 8-year sentence is pretty light, but it is within the upper range of the actual offense charged. I just can't imagine leaving somebody there on the side of the road, no matter how much you fear the cops. It's just your instinct is to just stop and help somebody when they're hit, and he just took off. So we would ask for 8-year prison sentence.
Go ahead. Defend.
Judge, certainly his injuries, Mr. Jones' injuries are severe. Mr. Medina made a terrible decision to leave the scene. I don't think anybody can argue with that. If you look at Mr. Medina's statement, he panicked, went home, and his intentions were to call the police. It's just the police got there before he could make that phone call. We're asking the court to consider probation. He has accepted responsibility, accepted, once the police got there, he didn't deny that it was him that was driving the car. He readily accepted it was him. He's coming to court and plead guilty to it, Judge. Mr. Jones is asking for restitution. As I say, Mr. Medina's insurance is paid. I don't know, I don't have the information in front of me. I would believe policy limit's about $30,000. Certainly his bills are more than that, to be in the hospital for 8 months. Mr. Medina is working. He's always had a job. He's working construction now. He would be in a position to make payments towards restitution. The court could order that payments go first to restitution, then if we were to put him on probation. To try to make some restitution to Mr. Jones so that we can hopefully give him a little bit better life than he's got right now, which he certainly deserves after going through this. Mr. Medina has a limited criminal history. He's got one case where he was on probation for marijuana, a deferred adjudication. Looks like he successfully completed that. As far as I think that's the only adjudication that he's got in the pre-sentence investigation. He has a support system. Both parents are available to him. He has a sister that lives here in Beaumont, and it appears that they get together regularly. They are able to support him in any way possible. We're asking for a chance on probation, Judge. I looked at the PSI. It looks like they're recommending that if you were to give him probation, save P. And if that's something the court wants to do, obviously we can't complain about that. He just is asking for a chance to continue his life, make restitution payments to Mr. Jones.
How much is the restitution?
I don't have anything.
There's no amount.
Mr. Jones.
It's that's something probation can determine at some point.
I think the victim in this case wishes restitution, but there's nothing based that I have a basis to order, except to order restitution in an amount to be determined, I guess. But
And it doesn't look like, I think if probation is to determine restitution, I don't think they have a problem getting in touch with Mr. Jones. He gave a pretty detailed statement.
I'm going to ask that no matter what happens, restitution is going to be ordered in an amount to be determined. But all the parties agree that restitution is owed here, and it is going to be ordered in some amount, but I can't just say a number now because there isn't anything here that causes me to be certain, and I want to be accurate, and the victim needs to be heard into how much he's going to he needs to receive in his losses, based upon his losses, but anything else?
No, Judge, but I think Mr. Medina would like to make a brief statement.
Go ahead, sir.
Yes, sir. I understand that I did wrong.
What did you do wrong?
Leaving that man.
Why did you do that?
Sat there.
So you knew somebody had been injured, somebody is laying on the ground, and you just drove off?
That's correct.
Sir?
That's correct. I
I'm
wish I
glad
was out there.
somebody didn't run over him after he had been injured. He's just laying on the road? For others to clean up the mess that you had caused? That's so inhumane.
I understand.
Okay,
I wish I would have done things different.
well, but the police arrested you later that day? How long after the event?
Even maybe an hour.
Happened. But up until that time, you weren't about to turn yourself in, right?
I wouldn't. Yes, sir.
You didn't. Apparently 30 minutes with somebody knowing someone was laying on the ground that you had caused injuries to, that, and for a half an hour, that didn't bother you to call the police and say, it's me. What do I need to do? They had to come get you, right? So, yes, okay. It's a bad thing altogether. All right, anything else?
No.
Here's what the court's going to do. We have a multi-level a set of circumstances here. This is like a bar exam. Because there's different dynamics involved in this one. I'm going to find that you, Mr. Medina, have pleaded guilty to this third-degree felony of collision involving serious bodily injury or death. Guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in your plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony. Now, the agreement is whatever sentence shall not exceed a cap of 8 years confinement, which puts the court in a position of three different options: deferred or unadjudicated probation, which is foreclosed now because I have found you guilty of this felony beyond a reasonable doubt. We have regular probation up to 10 years in length, and confinement in prison. The state is asking for confinement, and your attorney is asking for probation. The state's request is certainly reasonable.
It's also based upon what the victim wants to, Judge. Complaining in the case.
Here's what, and I've seen this, the victim has all, between his physical problems and his monetary loss, he is in a bad situation. Here's what the court is going to do. I am going to sentence you to 8 years in prison. Everybody listen and hear me out. That will be suspended. You were placed on regular probation for 10 years. Number one, as a condition of probation, I can place you in a jail for 180 days. I'm going to do that. You're going to have to do 6 months in jail. After that, you are going to go directly to a substance abuse felony punishment facility and complete a substance abuse program. You will also be ordered to pay restitution to this man, and it'll be whatever his full losses are that are still that we all the parties agree are necessary, but are not determined at this time. Your statements here in this pre-sentence report about your let's see, marijuana use, which is overwhelming for years, daily, from the age of 15 to December 2025. How old are you now?
32.
32. 17 years of marijuana. Cocaine from 28 to December 25, frequency on weekends. You're also going to do this. You're going to be ordered to fully cooperate with law enforcement on the sources of these drugs that you have acquired, and you're going to take a polygraph test. And if I catch you lying, that'll be another reason that could be used where your probation could be revoked. The state's request is certainly reasonable, but you need some other help as well as confinement. And you're not going to get it by going to prison. And the poor victim here needs his value and his expenses paid, which are going to be thousands of dollars. which you're going to be responsible for, which you would not be if you go to prison. But you're going to be in a facility, a prison-like facility for at least 9 months, which is maybe less than what you deserve from what the victim's problems are. You've made a big mess here, but the biggest mess is your decision to use drugs illegally. And every one of those instances is a crime in itself. So every one of those, and you're doing it for years. You've been doing it for years, but between cooperating with law enforcement as a condition of your probation, going to confinement in jail for 180 days, which is the most I can order, and going from there directly to substance abuse. I don't want his feet touching the ground until all of this is accomplished, and you cooperate with law enforcement and they send something back to me that you have been that they're satisfied that you cooperated. Those are going to be included with the conditions of the other conditions of probation that we normally assess.
Do you have orders, Judge, that probation's asking if you have a set of orders
don't.
underneath your file? Is this underneath your file here? Is this?
Oh, I'm sorry. I know, I didn't. Over here. They always send it to me. Here's some special, you have special conditions as well. This is the substance abuse felony punishment facility special condition. I'm signing on this day.
Oh, you're good, but we want to. We come on my side, you're good. You feel better, let's see if I want them wrong. Yeah. $1,000. My business is.
There's no fine because the restitution is going to be,
Thank you, Jeff.
is going to be, I'm putting TBD, to be determined.
Yes, sir.
Okay, also 180 days.
Yes, sir.
And when do we begin this? You report in Friday,
Right.
on or before 6:00 PM. You understand, sir? It'd be. Is
This
it?
coming Friday?
There's 31 days in April, right?
30.
Yes,
30.
30?
30 in April.
Yeah, okay, tomorrow's Friday. Okay, got it. So you want to check all of this, because
Yes,
that's all I'm saying.
And once you sign all those orders and they get sent over to the jail, that safety hold will be placed on him anyway.
Yes,
So once he completes that 180 days, he'll have that hold, so he won't be able to step foot off the ground.
yes, sir. Thank you.
Yes, sir.
It's the plan. For the orders, that's. Anything else?
No, Judge.
That is all. Your assess on this.
So we need fingerprints.
You guys let me know what you think in the chat, but that sentence works for me. I mean, the guy had a whole ton of injuries and stuff, but he's going to need restitution. And if you put him away for 8 years, then there's no chance of him seeing a dime. At least now he's got a chance. So I think that works. If you see it different, let me know. You know, there's a real tension in cases like this between the idea of punishment and the idea of making things right financially for the victim. And that's something that the court always has to grapple with. Let me know how you think Judge Stevens handled it in this particular instance. I'd be curious your thoughts. And if you enjoyed this video, do me a favor and check out one of the two that are on your screen right now. Thank you for watching.